Hi everyone, it's Jackie, and today I'm going to go over the case brief for Students for Fair Admission Incorporated versus Harvard College. This case originated back in 2014 and it is still going on today. So, just a quick introduction to the case. The following are the parties involved. The plaintiff is the Students for Fair Admissions Incorporated, which is a nonprofit organization that is anti-affirmative action and seeks for all students who are applying to get into college to have a fair and equal opportunity. And the defendants are the president and fellows of Harvard College. The court that this took place in is the Federal District Court. So this case has been going on for quite some time. It began in 2014 when the Students for Fair Admissions filed a complaint against Harvard College stating that they had broken Title VI and were participating in racial balancing when they were admitting students into the university, and specifically that they were discriminating against Asian American students who were applying to the university. In 2015, many Harvard students filed a motion to intervene, which was denied. In 2016, Harvard moved to dismiss the lawsuit due to lack of standing, and they wanted judgment on pleadings for 2 out of the 6 counts that were brought to their attention. They wanted 2 out of 6 of those counts to be dismissed, which ended up being approved. In 2018, the case proceeded to trial with the 4 remaining counts that were brought against them. In February 2019, the closing arguments were heard, and then it took a few months, but in October 2019, the federal court offered their ruling, and then a few weeks after that, the plaintiff then filed for an appeal, but we'll get to that in a little bit. However, the case is expected to land in the Supreme Court in the future. So, shifting over to the facts of the case, the Students for Fair Admissions filed this suit against Harvard, claiming that Harvard was discriminating against students in their application process based on race, specifically saying that they were discriminating Asian American students and holding them to a higher standard than any other race or ethnicity. This was brought to the Students for Fair Admissions by an Asian American woman who had applied to go to Harvard and believed that she was well overqualified. However, she was denied, which she suspected was due to racial balancing, where Harvard would only admit a certain percentage of each race into the university in order to balance the diversity on campus. And she believes that Harvard had already reached their Asian American quota, and that is why she was denied. So, through this, the Students for Fair Admissions claimed that Harvard was violating Title VI by the following 6 claims, which were intentionally discriminating against Asian Americans, using racial balancing, failing to use race merely as a plus factor in admissions decisions, failing to use race merely to fill the last few places in incoming freshman class, using race where there are available and workable race neutral alternatives, and using race as a factor in admissions. So, like I mentioned in the previous slide, Harvard had requested that 2 of the counts be dismissed from the case out of these 6 that I just read, which ended up getting approved by the court. Those 2 counts that were dismissed were failing to use race merely to fill the last few places in the incoming freshman class and using race as a factor in admissions. So those 2 counts were dismissed, preceding the rest of the case, and they moved forward using the other 4 counts. So, a little bit of a history on the issues with Harvard admissions. This was why the plaintiff was able to build such a case because Harvard has had a lot of issues in the past with discriminating students from being admitted due to race. So, the first time that Harvard had an issue with discrimination was in the 1920s. The Harvard president at the time decided to put a cap on the number of Jewish students that could be admitted to the university. He decided to do this after deeming that the university had a, quote, Jewish problem when he realized that 20% of Harvard students were Jewish. His fear with this is that if the population of Jewish students continued to grow, that Christian students would no longer want to attend, and Harvard would become a Jewish college. After realizing this, he decided to have students identify their religion on applications and discuss in committees different students that they think might have lied on their application and focusing on getting them removed from the university. His goal with this is that he wanted the population of Jewish students to be lowered from 20% to 15%. However, these tactics were not working, and over the next 5 years, the population had risen to 27%. It was only after the president decided to have students include a photo of themselves on their application where the Jewish population had dropped within 1 year from 27% down to 15%. Harvard continued to employ these tactics over the next couple of decades. Once the 1960s arrived, Harvard decided to focus on trying to admit more African American students. At first, they only admitted African Americans from socioeconomically challenged areas, but then upon seeing how they transitioned into Harvard and that they decided that they were struggling too much as they were getting acquainted with Harvard, they decided to only admit African Americans from wealthy families. It is alleged that to this day, Harvard is still engaging in this kind of racial balancing where they're controlling how many students of each race are being admitted, and that is kind of the backstory on how this current case came to be. So, after looking at this case, there are two big issues that came to be that essentially the court was trying to answer, which were: does Harvard College admit only certain percentages of each race in order to keep a racial balance? And are Asian American students held to a higher standard to be accepted into Harvard College? So, moving on to the holdings, the Federal District Court ruled in favor of Harvard College, deeming that Harvard had not used race as a deciding factor when it came to admitting students. They often referred to a previous case that was heard by the Supreme Court, which was pretty similar, and in that case, it was ruled that race could be used in the admissions process. So it was decided with these two universities that they did not have a quota for these specific races when they were admitting students into their universities. Moving into the rationale, as I mentioned before, the ruling for this case was largely influenced by the Regents of University of California versus Bake ruling. In this case, they were under scrutiny because they had admitted most of their minority students through a, quote, special admissions program. Through this program, they were able to give 16% of their spots out of 100 to students of color. This was deemed unconstitutional because it used explicit racial classification and only admitted certain students based off specific racial identities. Harvard's admission was deemed flexible enough not to show that race was a deciding factor on admission and that racial minorities were seen as a plus. No evidence was shown that the Asian American students were held to a specific standard that was higher than any other student. So, since there was only one judge for this case, since it was at the federal district court, there were no dissenting or concurring opinions for this case. That could change if the case eventually moves to the Supreme Court, but for now there were none in the original hearing. So, in looking at the educational, ethical, and social implications for this case, it really brings up the fact that universities lately have been pushed to make sure that their campuses are more diverse when it comes to race, ethnicity, religion, sexual orientation, socioeconomic status, etc. So, if universities are using certain percentages for different backgrounds to make sure that they have representation from every group, this case really looks at whether or not it's okay for them to turn away applicants that are qualified for admission due to the fact that they have already reached their percentage that they wanted for different groups. It is important to point out that the judge did rule in favor of Harvard in this case, depending on how the appeal process goes and if the case does end up in the Supreme Court. The findings on this case could have significant impacts in other universities who may be participating in racial balances in order to use race simply as a diversity factor rather than admitting students based off of their credentials. So, to begin wrapping up, there is a discussion question that I wanted to pose to all of you. So, in a world where diversity has become a requirement in most vicinities, in order to ensure diversity at elite universities, is it ethical for admissions to strive to maintain specific percentages of varying cultural backgrounds. Why or why not? And then if your answer is no to that question, I'd like to know how can universities ensure diversity if they aren't creating those percentages and ensuring that their university is still a diverse campus where different students can have other groups they can relate to. So with that, that concludes my presentation. I tried to make it as streamlined as possible. It was a very large case with multiple different moving parts and updates, even updating as recently as a couple of weeks ago. So I do apologize if I missed any information. I tried to give out the information as streamlined as possible so I wasn't spending too much time on the little details, but I hope that this was able to give you all a pretty basic idea of how this case operated and how it's going to be proceeding in the future. So, thank you for listening, and I hope you all have a great week.